you and welcome. I want to talk about the options that are available to Jacob Zuma in a moment, and his next court appearance is on June the 8th, as we know. But in simple legal terms, explain to our viewers today what happened and why it was so brief and why it was postponed.
Good afternoon to your viewers, firstly, Jeremy. Jeremy, you see what happened today was just a warm-up, I should say, of the actual battle when it comes. You will notice that when the prosecutor was talking, he mentioned that they went to chambers to brief the judge first about the appearance. It's a normal thing that each time that you go to a court, any lawyer goes to a court, you must go and introduce yourself to the judge, to the magistrate, so that he knows what is he dealing with. You know, there isn't a perfect lawyer, so to say. You have your limitations and your inadequacies. That's the time to show them to the judge that I'm thin on this area, and in this area I'll need your guidance. Of course, the judge will. And
lawyers from both parties would have been in chambers in that
Indeed, indeed. So you will see also that what we had today was an arrangement that comes from there. You see, a lot of the things that happen there would not happen in an open court because they are give and take. You consent to them because you know, in any event, even if I was going to go and make an application, the decision of the judge is already settled. It's a point in law which is already settled, like what was being said, that we are now going to wait for the application. The papers are going to be accepted before the end of May. That is a given.
And Chrispen, also about officially getting this onto the court roll.
Yes, indeed.
One of the problems that was pointed out, it's a very crowded court roll, so there'll be another appearance in June the 8th, but it could be November possibly by the time we actually see this go to trial, if in fact it does.
You see, Jeremy, there are our constitution and various acts put a lacuna around the accused person to protect his rights. One of those rights is to be given the docket contents. Normally when you have received this docket, you will also say, I don't see X, Y, and Z. So between now and June, all those things will be a back and forth process up until November, as he said. But even in November, I with what has transpired, with what we have seen here, I am doubtful that we will see a trial this year.
Because there are a number of options that are available to former President Zuma. So one is to review the decision to prosecute him. The second one is applying for a permanent state of prosecution. We can also talk about money, because this is costing an enormous amount of money. The accused could run out of money, and then this approach where there's appeal after appeal after appeal. So let's look at the first one then. Zuma's legal team saying today it's going to seek a review of the National Director of Public Prosecutions, Sean Abrams' decision that there was no reason for him to stand trial. What does that mean then? What is this review process? How does that work out?
You see, Jeremy, in our law, we have got two procedures that you follow in everything. You either attack the process or the substantive part, the merit. Now, the merit part is what is going to be decided by trial. The procedural part are these steps that we'll be taking one by one. Now, when a defense team says they want a review, they are saying, up until now, the procedure that has been followed disadvantages the accused person. And that disadvantage is to such an extent that the matter could be thrown away if everything is considered.
So let me just get this right in my own head. The review process is something which the prosecution would be asked to do, or is this simply within the jurisdiction of the judge who can grant that order?
Okay. This is how it pans out. They are going to write their papers before the end of May. The papers will then be sent to the Directorate of Public Prosecutions. Now that we know already that Billy Downer is the one handling the matter, they will be sent to Billy Downer. He considers the papers and decides, should I oppose this application or not? If he finds it fit that he has got legal grounds to, and I think he has, he will then oppose. And then the defense team is given the last option to reply to his papers before the matter is set down for the judge to hear it.
Fine. So assuming that review process fails, the next option, I understand, is a permanent stay of prosecution.
Yes.
So how would that be different to the review?
The points that you include in the applications are different. You see, the first one, you are dealing with the procedure of how the Director of Public Prosecutions has come to the stage to say, I'm now prosecuting again. But in the permanent stay of prosecution, you are saying, considering all that has happened, the time that has passed, you know we are now in the 13th year since his first appearance on these matters. There are decisions made by other judges. All that will be included, and then they will pray in those papers for saying these charges must be thrown away. I must be frank with you, that is a tough ask, because all what we are asking for, the reason why these charges have been put back on the roll, there is someone else who was convicted of the same charges. So it will be very difficult to succeed with a permanent stay.
All right, so you've actually just preempted my next question, because my initial thinking was, would this not be a better strategy than going for the review? But it seems the review has more chance of succeeding than the permanent stay of prosecution.
Yeah, okay. It would look like that, but you must remember one thing. There is no, as long as these options are there in our law, you are allowed to take all of them as much as you want. But once you have exercised that right, you do not exercise it again. So there is another one. There's another option that we forgot to mention.
Yes.
Besides those two. Just to say, put these two options aside and let me stand trial. That's another option. And we will get a trial date and all these things that he's talking about. And you saw his address when he was outside court. He was mentioning
the political conspiracy. Yeah.
That is the time for us to hear it.
Okay. Let's assume, though, so that's option 3. Now there's option 4. Okay.
Yes.
We know that President Ramaphosa at some point is going to have to decide whether to fight a DA application to stop the continued state funding of this particular process.
Yes.
Let's assume that he decides to stop state support.
Yes.
That could surely affect the defense strategy of President or former President Zuma.
Surely. But you have
This is not a cheap process, is it?
No, it's not a cheap process. Far from it, Jeremy. You see, all these options that I was giving you, because of the bulkness of the documents which are going to be used here, you are talking about thousands and thousands of pages. So each process, in my eyes, is not going to call anything less than 2 million. Looking at what is happening now, it's not going to call anything like that. But you must remember one thing: if the president Cyril Ramaphosa does say, "I'm not going to fund this process anymore," then the former president is entitled to apply for legal aid. This is an option which is available to everyone. Even you, Jeremy, if you are arrested today, you can apply for legal aid. But
it would affect the quality of the people representing him, or is that unfair?
That's correct. It would affect two things. It would affect the quality of the people that are representing him, and normally you don't have a choice as to who is going to represent you. You are given, depending on what is available. And then secondly, there is a means test that you must pass. There is a means test that you must pass to qualify for legal aid. So it's not going to be easy. And I don't think you will pass the means test, because as it stands now, you are looking at someone who earns less than 6,000.
Okay, fine, and we need to be quick on this one, because I know my team behind me is saying all sorts of things in my ear to wrap it up. Let's assume the trial goes ahead.
Yes.
Okay? Either this year, as Billy Downer is suggesting, or not. What then happens, if there's any sort of judgment, then we would also see appeal after appeal after appeal, which is either the fourth or the fifth strategy. Am I correct?
Yes, that's correct. That's correct. But you see, Jeremy, the legal process has shown us in so many ways. You remember the Nkandla matter. It went back and forth until it reached the Constitutional Court. But after it reached the Constitutional Court, it looks as if everybody was satisfied with the outcome. I am sure, even in this matter, we might not be happy right now because the steps that are being taken are slow and to the extent that you can say it's painstakingly. And eventually, it is going to reach the Constitutional Court and all we are going to be happy.
Chrispen, thank you very much for the sharp clarity. I really do appreciate it, and it's so good of you to come in again. Thank you very much indeed. Attorney Chrispen Machingura.